If you have any kind of immigration case in the United States right now, a visa renewal, a green card process, an asylum claim, a work permit, a family petition, or you are living without status and keeping your head down, you need to pay attention to what happened in Washington this week, because the House just pushed forward 3 major immigration bills in February 2026 that could change the rules faster than most people realize. Welcome to Immigration Updates Hub. We cover immigration updates for regular people, not lawyers, not lobbyists, not political junkies. So we are going to translate what matters into plain English, keep it practical, and give you an action plan you can start today. Here is the big picture. One bill is built around tougher border and interior enforcement. Another bill tries to speed up and modernize legal immigration and reduce backlogs. And the third bill creates a long conditional route for certain undocumented people to earn legal status over time. That combination is exactly why people are feeling 2 emotions at once, hope and fear. Because depending on who you are, one part might help you, while another part could put you at risk. And if you live in Texas or you have family in Texas, this matters even more, because Texas sits at the center of the border conversation, and it also has one of the largest immigrant communities in the country. Now, let us walk through what each bill is trying to do, who it could affect, and what you should be doing while the Senate fight plays out. Because the mistake we see over and over is people waiting until something becomes law, and then they rush. And in immigration, rushing usually means mistakes, missed deadlines, and bad paperwork that follows you for years. Bill 1 is the enforcement-heavy package. The core idea is simple. More money, more technology, more agents, more detention capacity, and tougher consequences tied to unlawful entry and certain violations inside the country. In practice, the bill sets up a large multi-year funding stream for physical barriers, surveillance systems like cameras, sensors, drones, and monitoring towers, plus a major hiring push for border personnel and interior enforcement officers. The numbers can be huge, tens of billions across a few years. What it buys is manpower and infrastructure, which usually means more encounters, more stops, more workplace visits, more detention beds, and more capacity to move cases quickly. One of the biggest shifts is how it treats asylum at the southern border. This bill tries to end or sharply limit release for many asylum seekers by keeping more people in controlled processing, including processing centers outside the United States where initial screening interviews happen before someone is allowed to enter. Another piece is the push for speed inside immigration court. When the government sets strict timelines like completing detained cases in months and non-detained cases within about a year, you can end up with people who do not have enough time to find an attorney, gather records, get affidavits translated, or collect medical proof. The third part of the enforcement bill, and this is where lawful immigrants need to listen closely, is how it expands the list of issues that can trigger removal proceedings. Proposals like this often broaden the definition of what counts as a removal trigger by adding a new category tied to public safety. That can include certain driving offenses, repeat traffic violations, some misdemeanor domestic violence findings, and select drug possession charges. Depending on the final language, even a longtime green card holder can end up facing immigration consequences for conduct they thought was behind them. Let us make that real with a story. Imagine a man named Carlos in Houston who has had a green card for more than a decade. He works, pays taxes, his kids are citizens. Years ago, he got a DUI. He handled it in criminal court, did the classes, paid the fines, stayed out of trouble, and moved on. Under a tougher enforcement framework, that old case can become the spark that puts him in removal proceedings. Now he is in immigration court fighting to stay in the only place his children call home. The point is not to scare you into panic. The point is to make you stop assuming that a green card makes you untouchable or that an old misdemeanor is invisible. If enforcement expands, the safe move is to treat every legal issue as potentially immigration relevant and get proper advice before you plead to anything. That is Bill 1. More enforcement capacity, stricter handling at the border, faster court timelines, and broader consequences for certain violations. Now, Bill 2 swings the pendulum in the other direction because it focuses on legal immigration reform and backlog reduction. This is the bill that many skilled workers and family applicants have been praying for because the current system can trap people in decade-long waits. One of the most important changes is how it handles country-based limits for employment-based green cards. Today, caps limit how many green cards can go to nationals from any one country each year, creating massive backlogs for high-demand countries. The reform approach is to remove or relax those country caps, so visas are issued by priority date, meaning who has been waiting longest rather than by country of birth. If that becomes law, it can dramatically change the timeline for many people from high-demand countries who have been stuck in the queue for years. The bill also raises the overall number of employment-based green cards available each year. That matters for industries constantly hiring like healthcare, engineering, and technology. More visas and more rational allocation usually means less waiting and fewer years living in limbo. But Bill 2 is not only about work visas. It also reshapes parts of family immigration. The House version increases the number of family preference visas and creates a faster processing lane for some immediate relatives like parents of adult citizens. Here is the catch. Bills that shift numbers around often do it by taking from one category to feed another. In this proposal, one family category is likely to be reduced or eliminated for new filings, especially the category that allows citizens to sponsor siblings. If you are from a community that relies heavily on sibling petitions, that is life-changing. Sometimes proposals include grandfathering, meaning if you filed before the law takes effect, your petition can continue. But if you did not file in time, you might lose that route entirely. The bill also pushes for modernization, a more complete shift to digital filing, better online tracking, and expanded premium processing. Now, before you get excited and start making big life decisions, here is the grounding point. A bill passing the House is not the finish line. The Senate can rewrite it, split it, merge it, or block it completely. If you are in an employment backlog and this reform sounds like a miracle, do not quit your job or make irreversible moves based on a proposal. Treat it as a potential tailwind, not a guarantee. Keep your status clean, keep your filings consistent, and be ready to move quickly if the law changes. That brings us to Bill 3, the most emotionally charged one, because it deals with undocumented immigrants and creates an earned pathway to legal status. Let us strip it down to mechanics. This is not immediate citizenship. It is not a magic reset. It is a long conditional process that says, if you meet strict requirements and stay clean over a period of years, you may eventually reach a green card and then later citizenship. The proposal sets a cutoff date for continuous presence tied to early 2020, meaning you must have been living in the United States since that date to be eligible. If you arrived after the cutoff, you are likely out. It sets criminal bars, generally excluding anyone with felony convictions. It requires background checks, biometric screening, proof that you are working, in school, or serving as a primary caregiver. It includes English and basic civics requirements. If you meet all of that, you apply for a temporary lawful status that lasts for years, often close to a decade. During that time, you keep working or studying, pay taxes, avoid criminal trouble, report regularly, and renew on schedule. After that conditional period, if you stayed compliant, you can apply for a green card. Then, after the standard waiting period, you can apply for citizenship. The timeline from undocumented status to citizenship is long, often more than a decade. The difficult part is the proof. A bill like this demands documentation showing you have been physically present since the cutoff date. Leases, bills, school records, medical visits, bank statements, employment records, tax filings, and sworn statements from people who can verify your presence. Here is the problem. Many undocumented people survive by staying informal. They pay rent in cash, they work jobs paid in cash, they avoid paperwork because paperwork can feel like risk. So when a pathway requires a paper trail, a lot of eligible people struggle to prove what they lived. The proposal also includes significant fees, potentially thousands per adult, plus additional fees later and eventual naturalization costs. Let us bring in a realistic example. Picture a woman named Marisol in San Antonio. She came several years ago with her children and has been working cleaning houses. Her kids go to public school. She has been here long enough to meet a 2020 cutoff and stayed out of trouble. On paper, she could be the type of person this program is built for. But her life has been informal. She moved apartments twice. In one place, the electricity bill was in someone else's name. For work, families paid her weekly without formal payroll. She has some messages, some money transfer receipts, some school letters, but it is scattered. If the application window opens, she is not just filling out forms, she is rebuilding years of her life into a timeline the government will accept. That can take months. This is why we keep saying preparation matters even before anything becomes law. Now, what happens next? These bills pass the House, but the Senate is a different battlefield. The Senate can demand major changes. Sometimes bills get merged. Sometimes the most controversial parts get trimmed. Sometimes bills stall completely. Even if the Senate passes something, the final text has to be reconciled and then goes to the president. And even after a signature, implementation is not instant. Agencies have to write regulations, build forms, train officers. So, if you are wondering, does this mean raids tomorrow or a new legalization form next month? Typically, no. The machinery of government moves slower than headlines. But slow implementation does not mean you should wait. It means you should use the time wisely while other people are distracted. So, what should you do right now? If you are undocumented and you think you might qualify under a continuous presence cutoff like early 2020, start building your proof file today. Treat your life like a timeline you are going to have to prove year by year. Collect school records, vaccination records, clinic receipts, apartment correspondence, bank statements, pay records, and any official letters with dates and your name. If you do not have formal documents for a period, think about who can write credible letters, like a landlord, pastor, teacher, coach, neighbor, or employer. Keep everything organized in date order with copies stored securely. If you have been filing taxes with an ITIN, stay consistent and file on time. If you have not been filing, talk to a reputable tax professional who understands immigrant situations. Avoid any criminal trouble, even minor. Do not assume a misdemeanor is harmless. If you have any past case, even dismissed, get the certified court disposition papers. If you are on a temporary visa, be obsessive about compliance. Keep your address updated. Do not work outside your authorization. Do not overstay. If you are waiting for an employment-based green card and reforms could reduce your backlog, keep your current plan intact, stay in status, renew what needs renewing, and be ready to act if the law changes. If you are a United States citizen who plans to file for a sibling and you see any risk that the category could close, filing sooner rather than later can matter. Finally, and this is non-negotiable, watch for scams. Every time big immigration news breaks, scammers show up. They will claim they can file applications before the government releases forms. They will pressure you to pay cash fast. They will promise guaranteed approvals. Real immigration work does not look like that. Use licensed attorneys or accredited representatives. Demand written receipts. Never sign blank pages. Never hand over original documents without making copies. Let us do a quick recap. The House moved 3 big pieces at once: stricter enforcement and border operations, legal immigration modernization and backlog relief, and a long conditional legalization route for certain undocumented people. The Senate and President are still ahead, and the final text could change, but the themes are already shaping what 2026 is going to feel like for immigrants in the United States. Even if you love one of these bills or hate one of these bills, the practical move is the same. Get your documentation tight, keep your record clean, stay in status if you have it, and do not let delay make decisions for you. The people who win in periods like this are not the people who guess correctly about politics. They are the people who prepare for multiple outcomes. So, here is what we want you to do after you finish this video. Do not spiral. Do not assume this is all good news or all bad news. Pick the category you fall into and do the next right step. Build your proof timeline if you might qualify for an earned status program. Tighten your compliance if you are on a visa. Handle any past legal issue like it could have immigration consequences. Keep your filings current if you are in a backlog. File family petitions sooner rather than later if a category you need could be at risk. This is how you protect your options while the government argues. Immigration Updates Hub will keep tracking what happens in the Senate, what gets amended, what survives, and what the realistic timelines look like once agencies start implementing. If you want those updates without missing them, like this video so it reaches more people who need it. Subscribe to Immigration Updates Hub so you stay informed as the story moves. Leave a comment telling us which situation you are in. Employment backlog, family petition, visa status, asylum, or undocumented and watching the earned pathway. We read the comments to decide what guidance to cover next. And if you want a smart next step right now, watch our next video on how to organize your immigration documents into a clean timeline file that is easy to update every month. Because when the rules change, the people with organized proof move first and stress less. Thank you for watching Immigration Updates.